If you run a company that ships or receives goods, you face this uh, hidden, potentially massive risk. You could end up signing a contract, effectively. That makes you liable for huge consequential damages, even if your own paperwork explicitly says no liability. Hmm. Today, we're diving deep into the legal quicksand behind that problem, the Uniform Commercial Code's answer to what lawyers call the battle of the forms. We're talking about the everyday messiness of commerce, right? Purchase orders fly out, acknowledgments come back with, fine print. And those papers, they almost never match up perfectly. But the good ship anyway, people perform, business goes on. So our mission today is to really dissect UCC Section 2207. We need to figure out, how does the code decide which terms actually make it into the final deal when the forms clash? And maybe more importantly, when does just performing like accepting the goods bind you to really aggressive terms you never explicitly agreed to, like waiving consequential damages? How high is that bar?
That framing is spot on, because we really are navigating a kind of trap set by just, modern high-volume business using standard forms. So our path today starts by contrasting the old common law approach, the mirror image and last shot rules, which were pretty destructive, with the UCC's attempt at a fix, which is 2207. Then we'll take that legal framework and apply it really rigorously to a key case, Diamond Fruit Growers v. Crack Corporation. We'll focus especially on that tricky conditional acceptance language and what courts really require for genuine assent.
Okay, before we get to the UCC solution in the case, what exactly was that old common law approach? You mentioned mirror image in the last shot. Why was it so bad? Why did we need the UCC to step in?
Yeah, it was pretty rigid, almost medieval, like you said. The core principle was the mirror image rule. It meant the acceptance had to be a perfect, exact mirror image of the offer.
Perfect, like zero changes.
Exactly. If you changed anything, even a minor delivery date, maybe just by a day, it wasn't an acceptance. It was treated as a rejection of the original offer, and your response automatically became a counteroffer.
Okay, I see the problem starting already.
Right. And that led directly to the really problematic last shot rule. Think of it like whoever sends the last piece of paper before performance starts wins.
Wins.
Yeah, wins. Because performing the contract, like shipping the goods or accepting them, was deemed legally as assent to the terms on that very last form, the counteroffer. So the party who managed to get their form in last, maybe with really one-sided terms, automatically got those terms into the contract.
Wow, okay. That definitely sounds unfair. It incentivizes just waiting to send your form.
Precisely. It created a perverse incentive. UCC 2207 was drafted specifically to get rid of that rule, to neutralize that timing game, especially protecting maybe smaller players who couldn't always control the paperwork flow.
Okay, that makes sense. So the UCC wants to find a contract if people act like they have one.
Yeah.
How does 2207 subsection 1 handle an acceptance that comes back with different or additional terms? How does it avoid immediately calling it a counteroffer like the old common law?
Well, generally, 22071 is much more flexible. It says that a response can still operate as an acceptance, even if it states additional or different terms from the offer. So usually you do form a contract based on the terms the parties actually agreed on in their forms.
And the new terms, what happens to them?
Those additional terms are treated as proposals to be added to the contract, and whether they get added is handled later under subsection 2. But, and this is critical to 207.1, has a very important exception. It's called the proviso.
The proviso.
Right. If the acceptance document explicitly states that acceptance is expressly made conditional on the original offer agreeing to the new or different terms, then and only then it's not an acceptance. It flips back to being a counteroffer, just like under common law.
Ah, okay. So that specific language is the trigger.
It's the magic language. And it's crucial because if the contract fails to form under 22071, because of that conditional language, you don't even look at 22072 for the additional terms. Instead, you have to see if a contract was formed by the party's conduct under subsection 3. It sends you down a different path.
Okay, this is where it gets really interesting then. That conditional language is the key, and we have a perfect case to test it. Diamond Fruit Growers versus Crack Corporation. This involved, I understand, leaky cooling units, damaged fruit, and a long-term business relationship with clashing forms. Let's analyze Diamond Fruit Growers v. Crack. First, what are the legally dispositive facts?
Okay, so the key players were Crack Corporation, who made large cooling systems, and Metalmatic, who supplied steel tubing to Crack. This wasn't a one-off deal. They had been doing business for about 10 years. The process was Crack would send purchase orders for the tubing, that's the offer. Metalmatic would then send back its own form, called an acknowledgement form, before actually shipping the tubing. That was their response.
And Metalmatic's form had some important terms, right?
Oh yes, very important, and very much in their favor. Their form included a broad disclaimer of consequential damages. It also limited Crack's remedy if the tubing was defective to just basically a refund of the purchase price or repair placement of the tubing itself. No compensation for any bigger losses caused by the defect.
And
Crucially, Metalmatic's form contained language stating that their acceptance was expressly made conditional on purchasers' acceptance of the terms and conditions on their form. That's the proviso language we just talked about.
right. And there was even some history there.
Yes, adding another layer. At some point during their 10-year relationship, Crack's purchasing manager had actually orally objected to these limitation terms, but Metalmatic refused to change them. Despite this objection, Crack kept placing orders and accepting the tubing.
So the tubing eventually failed.
It did. It leaked ammonia in a cold storage facility which damaged fruit owned by Diamond fruit growers. Diamond sued Crack. Crack then turned around and sued Metalmatic, seeking indemnity or contribution, basically saying, "Your defective tubing caused this loss, you should pay for it." Metalmatic pointed to its form's disclaimer.
Okay, sets the stage perfectly. And what was the core legal issue the court had to resolve?
The central issue was whether Crack's conduct, specifically continuing to accept and pay for the tubing after Metalmatic had included that clear, expressly conditional language in its acknowledgement, and even after Crack had objected, whether that conduct counted as assent to Metalmatic's limitation of liability terms under UCC 22071. Did Crack, just by performing, agree to give up consequential damages?
What rule did the court apply to decide this?
The court applied the rule directly from the 22071 proviso. Because Metalmatic's acknowledgement was expressly conditional on assent to its terms, it functioned as a counteroffer, not an acceptance. And since Crack never gave explicit, specific assent to that counteroffer, they didn't sign the form, they didn't send a separate confirmation saying, yes, we agree. The court determined that no contract was formed under 22071.
So if no contract under one, where did the court look?
They had to move to 22073, which governs situations where the writings don't establish a contract, but the party's conduct recognizes the existence of one like shipping and accepting goods.
Okay, hold on. I need to push back here a bit on the policy. Crack knew about these terms, right? Their manager even objected. They kept buying the tubing for years knowing Metalmatic had this conditional language and wouldn't budge. Isn't that just? Crack making a bad business decision or maybe being careless. Why should the court step in and protect Crack from terms they arguably knew about and kind of accepted through their actions?
That's a fair question, and it goes right to the heart of the court's analysis. The court directly confronted that argument. They reasoned that if they ruled for Metalmatic, if they said Crack's performance alone was enough to constitute assent to the conditional counteroffer, they would effectively be bringing the old common law last shot rule back through the rear door.
Because Metalmatic sent the last form with the conditions.
Exactly. And the whole point of 2207 was to abolish that rule. The court felt that rewarding Metalmatic here would undermine the UCC's purpose. So to prevent that and maintain neutrality, the court set a very high standard for accepting the terms of a 22071 conditional counteroffer. It requires more than just conduct. It requires a specific and unequivocal expression of assent to those new terms.
Unequivocal. So just buying the goods isn't enough.
No. The court said performance is ambiguous. Crack might have accepted the tubing simply because they needed it, maybe urgently for their own production lines, while still disagreeing with the terms. The court basically said both parties contributed to this mess by using conflicting forms and not clearly negotiating a single agreed-upon contract. Therefore, neither party should get the advantage of having their preferred unilateral terms imposed simply because of the timing of forms or subsequent performance.
Okay, that makes sense from a policy perspective. Avoid reinstating the last shot rule. So what was the final conclusion? Did Metalmatic's disclaimer hold up?
No, it failed completely because Crack never gave that specific, unequivocal assent to Metalmatic's conditional counteroffer. No contract was formed under 22071. Therefore, the court applied 22073. Under 3, the terms of the contract are those terms on which the parties' writings do agree, like, price, quantity, the type of tubing, plus any default gap filler terms provided by the UCC itself.
And the UCC gap fillers.
The UCC's default rules do allow for consequential damages and include implied warranties. They don't automatically disclaim liability. So, Metalmatic's disclaimer and remedy limitation, which were not agreed upon in both forms, dropped out. The UCC defaults kicked in, making Metalmatic potentially liable. The original jury verdict finding Metalmatic liable for contribution to crack was affirmed.
Wow, that's a really significant outcome. It means just having that expressly conditional language isn't a magic bullet for the seller if they don't follow through and get actual sign-off. Let's try to solidify this with another scenario. Let's flip it. Imagine a big artisanal salsa company. They need a new high-tech bottling machine. They send a very detailed purchase order to the machine manufacturer. Their PO is clear, but it also includes really prominent language saying the entire order is conditioned on the manufacturer providing a full 10-year warranty against any operational failure, plus guaranteeing full consequential damages if the machine breaks down and halts salsa production. Okay, so the buyer sends the conditional form first. Now, the machine manufacturer, they just ignore the details of the PO. They build the machine, ship it, and send along their standard invoice. And that invoice says, in bold print, all sales final, as IS, no warranties express or implied, seller not liable for any damages whatsoever. Contract here applying the diamond fruit logic.
Okay, good hypothetical. This tests the principle when the buyer fires the first conditional shot. The salsa producer's purchase order, with that strong conditional language about the 10-year warranty and consequential damages, isn't just an offer anymore. It's effectively a conditional counteroffer right from the start, similar to Metalmatic's acknowledgement.
Okay.
Now, when the seller ignores that
Yeah.
and just ships the machine with their own conflicting as-is invoice, what have they done? They have clearly not given the specific and unequivocal expression of assent that diamond fruit requires to accept the buyer's conditional terms specifically, that huge 10-year warranty demand.
Right, they send completely opposite terms.
Exactly. So the buyer's conditional offer was never properly accepted. No contract formed under 22071, but they shipped the machine and presumably the buyer accepted it. So we have conduct recognizing a contract.
Which takes us to?
Straight to 2273, just like in diamond fruit.
And the result under 22073.
The result reflects the UCC's neutrality policy. Neither party gets their preferred extreme terms. The salsa producer doesn't get their demanded 10-year comprehensive warranty and consequential damages. That drops out. But the seller also doesn't get their ASIS no liability disclaimer. That drops out too because it wasn't agreed upon.
So what are the terms?
The terms are the ones the forms did agree on: the specific machine, the price, delivery maybe, plus the standard UCC gap fillers. And those gap fillers usually include things like the implied warranty of merchantability, which is certainly better for the buyer than ASIS, but nowhere near the 10-year guarantee they wanted.
So it confirms the policy again. 2207 prevents either side from imposing their will just by sending a form, whether it's the first conditional shot or the last shot. It forces a middle ground unless there's real agreement.
Precisely. It pushes parties towards the UCC defaults unless they truly negotiate and agree otherwise, explicitly. So, let's synthesize this for you, the listener, especially if you might face this on an exam or in practice. Here's a kind of diagnostic checklist, drawing heavily from diamond fruit for tackling a battle of the forms problem under 2207. Step 1. Look at the purported acceptance form. Is it even a definite and seasonable expression of acceptance? Does it look like an acceptance generally, responding to the offer's core terms? If not, the 2207 analysis might not even start, but usually it is. Step 2. Scan that acceptance for the critical proviso language. Does it contain words making acceptance expressly conditional on the offer's assent to the new or different terms on that form?
Okay, that's the key fork in the road.
It is. If that expressly conditional language is missing, then it is an acceptance under 2207, and you proceed to analyze the additional different terms under 2207. Different analysis entirely. But if yes to the proviso language, then step 3. Recognize this response is not an acceptance, it's a counteroffer. Step 4. Now you must check for assent to that counteroffer. Did the original offerer, the one who received the conditional form, agree to its terms? And remember the diamond fruit standard here. Assent requires a specific and unequivocal expression. You're looking for something clear, like signing the form, a separate letter or email saying, I agree, something explicit.
And critically, not just.
Critically, not just conduct alone. Merely accepting the goods, paying for them, or continuing the business relationship is not enough to constitute assent to a conditional counteroffer, because, as the court said, that would just reinstate the last shot rule. So, step 5. If the answer is NO, Assent no specific unequivocal agreement to the counteroffer, then the contract is formed, if at all, only under UCC 2273 based on conduct. And under 22073, the terms are only those on which the ratings agree, plus the UCC gap fillers. All the disputed terms, the warranty disclaimers, the liability limitations, the aggressive warranties, they all drop out.
That's a very clear framework. So, boiling it all down, what's the big takeaway for businesses operating day to day? It seems performance doesn't automatically mean agreement, especially on the really tough terms.
That's exactly it. In the world of standardized forms and ongoing commercial relationships, the UCC, as interpreted by courts like in Diamond Fruit, puts the brakes on, automatically incorporating potentially harsh terms just because business continues. If you, as a seller, for example, want to enforce significant limitations on your liability or warranty, you can't just hide it in conditional language on your form and hope the buyer's performance seals the deal.
You need something more.
You need that explicit buy-in. The law essentially forces you, if you want those terms to stick, to actually negotiate them or get a clear, unambiguous sign-off. Stop the presses, as it were, and get confirmation.
And connecting this to the bigger picture, what's the policy goal being served here?
The broader policy is encouraging real negotiation over risk allocation. Instead of letting outcomes be determined by who timed their paperwork best or who had the leverage to make the other party perform despite objections, 2207 aims for fairness. It sets the UCC defaults, which are generally seen as commercially reasonable, as the baseline. If you want to deviate significantly from that baseline, the burden is on you to get the other side's explicit agreement. It protects parties from inadvertently giving up major rights just by carrying on business as usual.
Okay, final provocative thought for you, the listener, based on this. We saw Metalmatic failed because Crack's performance wasn't enough assent. Crack had objected orally, but kept buying. But what if Metalmatic, after Crack's objection, had sent a very direct email? We understand your objection, but we will not ship any further tubing unless you reply to this email, simply stating, I agree to the consequential damage waiver in your standard terms. And suppose Crack, needing the parts, replied with just that. I agree. Would that have been enough? Would that single email reply constitute the specific and unequivocal expression of assent the Diamond Fruit Court demanded, locking Crack into the waiver? Something to mull over. We hope this deep dive gives you a much clearer framework for navigating the UCC's approach to the battle of the forms, especially that tricky conditional acceptance. Drafting question right there.
Thanks for diving deep with us today.